Okay, so everyone can see the screen. Mariel, can you just confirm that for me? You don't
Yes, we
mind?
can see you,
Okay, good.
your screen.
Okay, good. So hello, everybody. I'm Lisa McGill. Hopefully you've joined us in the past, but if not, welcome, welcome. And as Mariel explained, last time we talked about the HOA legislation. There's a ton of legislation this year. There are a ton of questions about that. So we divided the class into two separate classes so that we can handle the condo stuff individually. The big bill this year for condo associations was 1021. They call that condo 3.0 or something along those lines. And the other legislation that I'm sure you're going to want to hear about is 1029, which is the My Safe Florida condo pilot program. Both of if you look at if you put your icon or your scroll over the little computer, those should be active links to the actual legislative bills. I'm having an issue here. Okay. So legislative activity. I'm a member of the Florida Legislative Alliance, which is the CAI group, that the statewide group made up of delegates from around the state who consist of attorneys and CPAs and insurance professionals and management professionals and contractors and all kinds of individual volunteer homeowners like yourselves, but we're board members that monitor legislation throughout the year. We go to Tallahassee to talk to the legislators about the concerns of HOA and condo communities, as well as their constituents. This year, we were tracking 75 bills. 5 of them actually passed. 2 of them we're going to talk about today. So just so you get a little bit of flavor of what we do throughout the year. And if you ever do track legislation, this stuff changes on basically a daily or at least a weekly basis. So it's a very, very fast tracked or frenetic process. And we try to do our best to avoid or curtail any really harmful legislation. We also do our best to insert items that we feel or through our constituents are beneficial to community associations and make your life as either community association managers or board members or homeowners a little bit easier. So the first thing I'll talk about is the 1029 My Safe Condominium pilot program, my Florida Safe Condominium pilot program. Okay, so there was 30 million allocated to the program, but that 30 million is the program itself is not active yet. There is a lot of work that the Department of Financial Services needs to do in order to prepare for accepting the applications. Just to give you a little bit of a comparison, the My Florida Safe Home program has been on and off, but it was established in 22, and the legislature appropriated $150 million. So between 1122 and 1223, that was the program year, there were 94,000 hurricane mitigation inspections performed and 23,000 grant applications approved. They did a survey of those who completed the grant applications and completed all the work that was associated with the hurricane mitigation efforts. And they're saying that their insurance premiums stabilized or dropped for close to 73% of them. Now, those are for individual homeowners. If we do have any individual homeowners out there, you can go ahead and apply for that My Safe Florida Home program for hurricane hardening for your house, but don't do so this year because the funds have already been dedicated. So as soon as this, as soon as the Department of Financial Services has it up and running, I encourage you to monitor it, get on the website right away, submit your applications, and do whatever you can do beforehand in order to qualify for the program. So in order to participate in the program, initially, you need at least a board vote or a majority membership vote to apply for the mitigation and inspection. That you can go ahead and do now. talk to your counsel about setting up the appropriate resolution, but there's nothing that's precluding you from going ahead and authorizing yourself as the association to sign up for the mitigation inspection. So the inspection report, and they'll be designated by the department. The department's going through a vetting process where it'll designate certain providers for the service. The report will identify improvements for the hurricane hardening, include cost recommendations, and it's supposed to include insurance discounts or issues about insurance premiums. I don't know how much that is going to be able to be answered, but again, that is the first part of the program. To apply for a mitigation grant, it's a big hurdle. Big hurdle, because you need to have 100% membership support for any of the buildings that are going to have hurricane hardening performed. Yes, that's very onerous. This is a pilot program. There's only 30 million dedicated to this program. Legislators have said we want to see 150 million dedicated to this program in year 2, and even more in years 3, 4, and 5. But the only way that this program is going to have a year 2, 3, 4, and 5 is if it's successful on the first shot. So for you smaller condominium associations out there, this might be even a better option for you, because it's a little bit easier to gather the membership support that you need in order to formally apply. You can't do that yet, though, because there's a form that needs to be prepared by the Department of Financial Services that has all the disclosure information. So when you do have your membership vote, and you can do so by written consent, should you so desire, which may be a little bit easier for you, then you're going to have the form that is published by the Department of Financial Services. And then, of course, there's all kinds of other little requirements associated with the application itself. I have them laid out here. But the most important thing, obviously, is for you to be able to apply for the grant, is that you have the support of the membership in the building that is going to receive any of these hurricane improvements or hurricane or hardening improvements. They expect the implementation to begin in the fall, and they have 600 grand, I heard, allocated for the initial inspection. So once, out of those inspections, those will be where they consider who is going to be approved for the grants. You're able to select your own contractors for the work that needs to be done. You just need to make sure that they're vetted and you provide the appropriate information to DFS in connection with your application. What types of improvements? Well, they'll do opening protections. Those are your windows and doors, garage doors, reinforcing Rule 2 wall connections, deck attachments, secondary water resistance, that kind of a thing. The grant calculations are based upon your contribution. So there's $2 awarded for every dollar that you spend, but there's limits, of course. $11 per square foot of roof, maxed out at $1,000 per unit, or 50% of the total cost of the roof. And max grant of total grant, if you're going to be doing roof and openings, is $175,000. When you do this work, you don't get the grant money until the projects are finished. There's a question here. So as far as questions are concerned, I'm going to try to look at them as we go along. It's kind of difficult for me to do both at the same time. But there's a question here: in a 20 building multi-condominium under one association, can each building apply individually? And the answer, I don't know exactly, but here's what I believe to be the answer. The association is going to be the applicant, but you only need to apply for hardening improvements in the buildings that need the hardening improvements, and in the buildings where you can gather the requisite membership consent. So if you have a 20 condo multi-condo association, and only 3 of them or participate in the inspection and are able to get the membership vote to move forward with the grant, then you'll apply for the grant for those 3 buildings. That's the way that I see it, and hopefully that'll work that way. I did see some chatter back and forth from staff members that inferred that the grant would be applied for all of the buildings, but that may not be feasible for most of the associations that want to apply. Okay, so let's get into the meat and the potato of what is going to affect you as board members, affect you as owners, and affect you as community association managers. The first thing that HB 1021 does is expand the jurisdiction of the DBPR. When the DBPR first started investigating the condo associations, they had plenary jurisdiction to investigate a whole bunch of stuff. Later, it was winnowed down to very specific items, record inspections primarily, but also financial matters and conduct of meetings or notice of meetings. There were several complaints to legislators over the lack of the ability of the DBPR to review or investigate other types of violations. So now they have the power to investigate conflicts of interest, failure to respond to inquiries. They can remove officers for accepting kickbacks or using debit cards inappropriately, and a whole host of other things. The new regulations or the new law requires the division to refer potential crimes over to law enforcement agencies. They're going to create a database that have created their structural integrity reserve study, which is, as an aside, they do have an email that you can send your structural integrity reserve study now, because you're supposed to send it to the division within 45 days of the completion of the study. A lot of you have already completed the study, but you have no idea where to send it. I will ask Mariel or Jeff to include that in the follow-up email to you, because I don't have that readily available. But you can go ahead and report it now. They will have a form for reporting it, and they will have a form for reporting it. So if you do report it early, they said they would contact anyone that reported it early and ask them to fill out whatever information is missing. The thing about the DBPR and how they're going to handle all these new powers is that they are also in a regrouping process as well. So I wanted to let you know that on August 29, I'm participating in a webinar with DBPR to talk about the 2024 condo legislation. Jeff put into the chat the link to the website where you can see the schedule of DBPR presentations. I don't know if the August 29 presentation is already on the calendar, because I don't know if they've created the URL for it, but please bookmark that site. Not only is my one presentation of interest, because we'll hear from the DBPR how they're going to be handling some of the new initiatives or their new obligations. Going forward, they have seminars, I think every 6 weeks or monthly, with Florida Bar participants and partners to talk about relevant or timely issues that concern community association, condo association operations. Another issue, another power that both the ombudsman and the DBPR get from this legislation is that if they so demand, they can attend your meetings. I don't know, none of my clients would have objected to a DBPR representative attending a meeting other than an attorney-client privilege meeting where no one attends other than the board members. But apparently that must have been an issue in the past. I remember when Spencer Hennings was the ombudsman, he would often desire to go to meetings, because if he's hearing complaints from owners, he'd like to see for himself, is this true? Is this not true? Can I talk to the directors? Maybe there are misunderstandings. And it was very helpful, I think, for him to be able to go to certain meetings. He also went to many meetings that were where there were election monitors, that he could observe that process as well. So the DBPR's role is expanding and changing, and we'll know when whether or how they're going to be addressing those issues. So there was a question here, do you have a sample board resolution for the application for inspection? No, I don't have a sample resolution. I'll be preparing that resolution as necessary for the clients who request that. There was another question about, is this for condos only over 3 stories? That's for 1029. I don't recall offhand, so I'd have to look to see if it's applicable to all associations, condo associations, or condo associations within the geographically located closer to the coast, because there is just a pilot program and they need to limit the number of applicants because they only have $30 million. Let's start about the mandatory condo board member education. I talked about the new education class. Yes, you board members, I know you've taken the education classes before. Most of them, I think, are 2 hours. I think we originally started with the board member education at 3 hours, and shortly discovered that it was difficult to maintain a level of concentration for a whole 3-hour period. So, and the providers that I'm familiar with, many of the law firms, community association management companies, there are, I know that there are accountants and other types of industry professionals that provide these types of education. They update it every year, at least the lawyers that I know do. But the class now needs to contain the curriculum that is mentioned here in the slide: milestones and SIRS, of course, always ours do; elections, meetings, and required notice, of course, ours do; record keeping and finding procedures. Ours definitely had a lot of time spent on record keeping and access to official records, because that is one of the issues or the primary issue, the most prevalent issue addressed by DBPR. I think you'll see with this legislation, there's a couple of different themes going on here. One of the big themes is transparency, or corporate operation transparency. So when it comes to official records, people complain that they can't get access to official records, or the official records are not being maintained. People complain that they were not able to get answers from board members at board meetings or membership meetings. People complained about some financial, they're unaware of the financial handling of the association. So you'll see that this year, the expanded enforcement, some of the fraud is addressed, education is addressed, and record keeping and access to records is really addressed. And that's addressed practically every year. And that's why we know how important it is and how prevalent it is. And I can tell you from my experience that if I never had to deal with another record inspection access complaint through the DBPR, I would be a very, very happy person. Sometimes it's just misunderstandings. Other times that you don't have procedures in place. So with this new procedure we're going to talk about in a couple of minutes, definitely encourage everybody that runs a condo association or CAM to encourage their boards to adopt specific procedures for record keeping, record inspections, to ensure there's compliance, because it's very, very easy to fall into a non-compliant situation. And there are enhanced penalties for repeat violations, which we'll also talk about. So you have until next June to complete your new education if you're an existing board member. And of course, new board members are going to need to have the new education certificate to submit to their association. Good thing is that it's good for 7 years. So you only have to do the 4-hour class, whether you do it at once or break it up into sessions, the way that we've discussed, once every 7 years. But you are required to do 1-hour updates each year. Our update class has also been submitted, and hopefully that'll be approved very quickly. Now, the way I feel about this is that the people on this seminar today and the people that want to be educated can be educated. There was no need to mandate a 4-hour class to educate people that want to be educated. They can participate in one of these types of webinars daily, more than once daily. They can go to live events where you get breakfast or you get, a chance to win a $25 gift certificate or something. And for those who are not interested in education, I don't know how much they will benefit by attendance, but the hope is that they really get an understanding of how operations are supposed to be designed by the statute, and so that they can be better able to fulfill their fiduciary responsibilities. This law also, let me just see if I can see. Okay, let me see if we can see. Let me look at the questions for a second. So 1021 also has requirements for community association managers. Just like the bill for HOAs, this one also has community association manager additional education requirements, but really what they were concentrated on this year were conflict of interest issues. So community association managers must return all official records within 20 business days of cancellation or termination of the contract. This is an important issue because I talked about those records and having the ability to enable unit owner access to records. Well, changing management companies creates a whole host of problems when it comes to record keeping, record maintenance, and record access. I've often recommended over the years that the association either hire an outside vendor or internally perform an audit of the records that are obtained from the previous management company in connection with a transition. Some of the time, if there are things that are missing, you'll be able to go back to the former management company and say, hey, we don't have, minutes from 2021, or, you've omitted the financials from June through September of 2019, or whatever it is. Sometimes they will have those records. You're able to obtain them. You're able to repopulate them in whatever system you're using, and that's great, then you'll have them. But if not, if those records are not available, then at least you will have a baseline knowing what you do have from historically and what you don't have historically, so that when there is a request for those records, you will know how to handle that. And if under the new law, there may be an obligation to recreate or, take efforts to obtain those records. But that's a really important thing, that when you're transitioning from management, or even when you're transitioning boards, people have stuff on their personal computers. You may not have an organized filing system, or it may not be filed electronically in a way that it's easy for someone else to take over. So no matter what, having an audit or having a review of your official records on a yearly basis, I think is a fantastic thing to do. Not that I want to saddle you with additional obligations. I just want you to be aware that it does take some work to know if you're going to be in compliance. But let's get to the conflict of interest issues. The management companies' managers have to disclose all conflict of interests. They've been doing that. If you look at your management contract, some of which are 5 pages, others are like 27 pages. There should be a big paragraph somewhere at the end, or maybe in an addendum, that says, we have relationships with the following companies that we may call on to perform services for your association. So they list a whole host of companies. But now there are additional requirements. So if they're going to be utilizing one of those services, and if the cost of the actual service is over $2,500, they need to get a competitive bid from a non-preferred vendor or a non-interested service provider for that particular service. Now, in an emergency, of course, there are exceptions to be made. You need ServPro or one of the other restoration companies to perform emergency water extraction or dry out mitigation type work. That's one thing. But if you're going to go with a big landscape contractor, those kind of contracts can be $500,000 a year on the very large communities. You're going to go with a contractor, you're going to go with other types of service providers, and there's some type of relationship there. The manager or management company has to tell you in the actual bid or in connection with the bid or the estimate that it's a company that has a relationship with the management company, and they're obligated to get you a bid from a non-interested provider. When the board is approving contracts and there's any type of interested provider, whether it's with a board member, a board member's spouse or a board member's cousin or what have you, or with one of the CAM companies, the contract itself must specify that the conflict has been disclosed or the interest has been disclosed, and the contract itself must be made available to the owners in connection with the vote on the contract. Contracts with interested service providers can be approved by the affirmative vote of 2/3 of the board members participating at the meeting. And if there is a contract with an interested provider at the next, upon petition, the 20% of the members can vote to cancel the contract, and that says without financial penalties. Of course, you'll have to pay for any services that were rendered prior to the cancellation. Official records, what do we need to know about official records in 1021? So let me see if I can see some of the stuff. Second. When it comes to the education, there's a question here. If a board was elected in March 2024, did they only have 90 days from being elected? Now, again, that was March 24 was before the effective date of the law. So I think you can be pretty confident in saying that that requirement does not apply unless the directors were elected after July 1, 2024. But regardless, you're going to have the new education. You'll have to have it you'll have to have it by next June. Let's go to the and there's another question here. I took my board certification before July 1. Is it still valid for 7 years? Anyone that took their board certification before July 1 will either have to take a new board certification course that's approved by the DBPR, or the DBPR, I understand, is considering supplemental courses. So if you have a certificate from before July 1 and you take an approved quote supplemental course, then you can pass by taking the additional 2 hours as opposed to taking a new 4-hour course. Official records. Now, the definition of official records has been expanded. I always thought that the official records included these anyway, but now it specifically says that invoices, receipts, deposit slips, and payment records are official records that need to be available for inspection by the owners. The statute did say that all documents reflecting any receipts or expenditures must be made available. And if you do working with a management company or an accounting firm, every month you receive a financial report. The financial report will have a full general ledger on it. The full general ledger does reflect all receipts and all expenditures for that period of time, but does not contain the source documentation, like the actual invoice that was being paid, or a copy of the check that was deposited or what have you, or a copy of the check that was paid. And now everything is done via computer or ACH. So it may be a little bit of an issue logistically with obtaining those records, but again, you still have to have them. So making them available could be as easy as updating or uploading them to your website. Building permits are also official records that have to be made available for inspection, and the board member education certificates. You have to keep the records in a quote organized manner. Organized manner that has yet to be defined. Maybe it'll be defined by the DBPR through rulemaking. You also have to make a good faith effort to obtain or recover records that are absent from your inventory. Sometimes this is relatively easy. So if you don't have your insurance policies from the 22 through 23, March 22 through March 23 calendar year, you can go back to your agent or to the carrier and say, hey, I need the insurance policies from 22, 23. For some reason, we can't find them in our records. Other records are more difficult to either obtain or recover. How are you going to obtain missing board member or membership meeting minutes? You have to go back to previous board members, go back to to the management company or previous management companies. And if you can't recover or obtain them, you can't recover or obtain them. So that could be somewhat of a difficult situation for you. I've had associations that have been required to go back to their bank and ask for bank statements for a period of time. And that, can be somewhat costly, but it's something that you're obligated to maintain. And if you don't have it, then you're obligated to try to do some to make sure that you can get it, or if it's possible, try to get it. Here's the big thing, and I put them both in red, so it's that it'll stand out to you. If somebody's requesting records and you provide the records, you have whether you provide it on the website, whether you set up a meeting where they come to your office, or you send them an email, however you're going to provide access to these records, you have to furnish a checklist of the records that were made available for the inspection. And then the checklist, go to number 5 on my little chart, the checklist must identify any records that you were not able to obtain. So if they say, I want the D&O insurance policy from the 21 through the 22 year, and you can't find the D&O insurance policy from the 21 through 22 year, and don't, don't hurry up and get it before your deadline for the inspection expires with 10 business days, then you have to put in your checklist, hey, we included this, we included that, we included the other thing, but we couldn't find the 2021 D&O policy. Please tell us if you still want it. We'll see if we can get it. You keep those checklists for 7 years. And what I suggest is that you just attach the checklist, your copy of the checklist, to the copy of the record inspection request itself. And I don't know how you maintain them. You can either maintain them in a file that has all your official records requests information, or you can keep it in a file by unit owner. But again, those records are going to be important to maintain for the 7 years. There are criminal penalties for willfully refusing to and willfully failing to provide access to records if your goal by changing the records, not providing access to the records, not maintaining the records, is to conceal some kind of illegal activity. But there are also, subject to penalties for just failing to have the records or failing to honor record requests. So that's why this issue may become more important to you. I put here it again, the contracts to be approved must be listed on the agenda, and either attach the agenda available for owners before the meeting where the board is going to approve the contract. Here's another issue, because you don't have necessarily the contract when you decide to approve the vendor. So you might have a bifurcated process where you say, okay, I approve this contractor to do the work, subject to the negotiating a form of contract that's acceptable, by the attorneys. Then when you finally have a final form of contract put together, you go ahead, you have a board meeting, it's only a 48-hour notice, and you say, okay, we approved so-and-so vendor, now we have the contract. I want to make a motion that we authorize the president to sign this contract. Now, the requirement, if you have 25 or more units, or more than 25 units, you need to have a website up and running. So make sure, contact one of the vendors so that you can get that website if you don't already have one. In my opinion, having the website and making records available on the website eliminates a whole host of problems. So if you can just say, I want this, I want that, I want the other thing, okay, it's all up on the website. Even financial records, you have private areas on your website. It's a beautiful thing. They can go right to the website. You don't have the logistics associated with setting up appointments and whether you're going to pull them out or whether you're going to allow access to the records the way they are maintained. But don't forget the checklist. If you're making them available on the website, make sure you still have that checklist and that you keep it for 7 years. Financial issues. Okay, financial reporting. Your report may be distributed electronically if you have the right to use email notice for items, but you cannot waive or reduce the level of financial reporting for consecutive years. So if you're over the 500,000, you need to do an audit. You can have your members vote to waive for the year in which the vote is taken, which means if you voted today, you'd be voting on the 2024 financial report. You're not voting on the financial report from 2023. You kind of fall into this trap when a lot of associations have their annual meeting in January and they want to waive or reduce the financial reporting for the year that just passed. No, that's not the way you do it. You have to do it in advance. And it's good that you do it in advance, because if you didn't, then you wouldn't know whether or not to put money in your budget for the audit, if it's an audit or some other level of financial reporting. Debit cards, just get rid of them. You're not allowed to use them, and if they're used for an improper purpose, it's going to be considered theft or embezzlement or fraud, so just get rid of it. If you're suspending voting rights, at least 90 days prior to an election, you have to tell everyone that you're suspending voting rights. Now, this is a double notice, because you'd have to tell someone before you suspended their voting right, and then you tell somebody after you suspended their voting right. But if that happened in June or July right now, and your election is not until November, and they're still suspended because they still haven't paid, you got to tell them again. Okay, and then the term kickbacks has been defined. And of course, there are criminal and civil penalties for kickbacks. Owner's rights. This is a kind of a quirky thing on electronic voting. Electronic voting is great. Some associations adopt it, but they don't necessarily utilize it for every single meeting going forward. Maybe this is an important meeting. Maybe there's a very controversial election. They want to authorize the electronic voting. Maybe you're voting on amendments and you really want to see if you can reach all those people that are just not in Florida or maybe traveling. So the electronic voting makes things a lot easier. But now, if this says in this law that if you offer the option and people opt in to electronic voting, you have to allow them to continue to vote electronically at subsequent elections. So talk to your counsel about that. You may want to investigate in using a vendor that allows you to have as many voting events during a particular year as you may want, or you may want a vendor that charges per voting event. Again, that's up to you. And also talk to your counsel about whether there's a way, should you like to discontinue electronic voting, if there is a way for you to be able to effectuate that. I saw some questions about this. if the condo has more than 10 units, you have to have, must hold board meetings quarterly. So somebody had asked, when does this begin? Well, the law became effective July 1, so it's effective for this third quarter of July. So this is now the third quarter. After October will be the fourth quarter. If you don't have them scheduled or you weren't planning on it, go ahead and have at least one meeting during this quarter and one meeting during the fourth quarter, and thereafter, hold your meetings at least once quarterly. Here's another thing, though. The members are entitled to ask questions about the status of construction or repair projects, revenue and expenses, or other issues at least at these meetings, regardless of the item is identified on the agenda. So apparently there must have been complaints that construction problems were ongoing and no one had any idea what was going on or how much they were paying or what kind of change orders were approved and whether or not there will be a need for additional assessments. So please be prepared to be able to answer questions related to ongoing items plus your revenue and expenses. And there's a whole section in this law when it comes to hurricane protection. One of the sections says that the unit owner is not responsible for removing and reinstalling hurricane protection if it's necessary to attend to the common area maintenance and repair. Where I see this is with shutters. If you're going to be doing a concrete restoration project, even if you're doing a painting project, a lot of times you need to remove and reinstall those shutters because you need access to those areas. Plus, a lot of times where the shutters are, the connections or where the shutters are affixed to the building need restoration themselves, and the openings need restoration. So now, again, this is a complicated issue because there are all kinds of confusing things in that portion of the statute. But as a general notion, this is saying that you're not going to be upcharging or allocating the cost associated for removing and reinstalling those shutters if it's necessary to attend to your maintenance projects. We always get the questions, though, what happens if the shutters can't be reinstalled because they're not code approved and the building department just won't let you reinstall them? Well, that is what it is. And in those situations, the individual unit owner, if the unit owner is responsible for either hurricane protection or their windows, will be required to either install hurricane rated windows or new shutters that do meet the code. Many of my associations, and I think this is a great idea, even if the shutters are individual, they have either a preferred vendor where they have a discounted maintenance contract for shutters, where the contractor will come out quarterly or even before, right after hurricane season, make sure that the shutters are operating properly, make sure that there aren't screws missing and all kinds of things going wrong with them, because it's very easy to forget to main shutters or not to think about maintaining shutters. And then, of course, the day you want to use them, you can't move them, or the mechanism doesn't work, or there are screws missing, and a whole host of other problems. So whether you do that as a common expense, of course, consult with your own counsel, or you do develop a program where you have a preferred vendor with discounted rates, for the people in your building. I think that's a good idea for community associations to think about. Wow, we have 65 questions and we only have about 10 minutes left in the seminar. So director officers offenses. So you can get charged if you are charged as a director or an officer by indictment or information, which is a criminal charge, with any of the three items listed here, then you're not eligible to serve and you're immediately removed from office. This is one of those places where the DBPR has the power to remove you if you don't relinquish your role as a board member. And then you're not eligible to run for the next election, if you're still under that indictment or that criminal case. Fraudulent voting activity. I'm not going to go through this laundry list, you will receive a PDF with the actual slides so that you can take a look at it. I would venture to say that the vast majority, if not 100% of you, have never engaged in any of these fraudulent activities, although you may have been somewhat persuasive or a little bit more persuasive with your campaigning. Campaigning is still allowed, though. So as long as you don't run afoul of any of the items on this list, you're not engaging in fraudulent voting activity, and you want to be a little bit vigilant about it too, because because your unit owners are unit, they're equal owners, or they have their percentage of ownership like anyone else. They need to have their say if they want their say. I mean, if they don't feel like voting, they should be allowed not to vote. And if they want to vote, they should be allowed to vote however they desire to vote for their own leadership. Okay, so, oh, good. So we're getting to the end here. So I just wanted to include a couple of these structural integrity reserve reminders, because you have to maintain them for 15 years. So when you have a request for a structural integrity reserve report, you may have more than one within that 15-year period. This is the last year, 12/31/24. That's the end for the community associations that are required to have the structural and the SERS reports of SERS funding to waive or reduce their funding. So if you haven't received your SERS report, you're kind of behind the 8 ball, but you still have a little time, because you need to get your ducks in a row and determine whether you can move money around, if you can move money around, whether you can get projects done, and whether or what your funding is going to be, so that to figure out whether you can go ahead and fund fully in 2025 under your the budget adopted prior to 12/31/24, or whether you want to waive or reduce funding, the SERS funding for 2025, because you're going to be doing major projects that's going to impact your SERS funding for 2026. Oh, I did put the email here. So here's the email for you to report your SERS to DBPR in the intervening period before they create that form. This law says that you can pause funding while the building is uninhabitable. So if there's a major hurricane and you can't even access your building, and there's a state of emergency listed for that area, you're able, or the building official says the building is uninhabitable, then you can pause your funding for that period of time, but you're going to have to resume funding as soon as the building does become habitable. And the DBPR, I think I said this earlier, they're going to create a list of all of the associations that complied with the 12/31/24 deadline, and they're going to do that through that form that I just mentioned. Wow, we covered a lot. So let's kind of see if we can get through some of these questions. Okay, there's a question here about SERS, so that's perfectly appropriate for the time. Reserves and SERS transfers. Do you need an owner vote to transfer? The answer is yes. The owner vote to waive and to transfer is a majority of the entire membership, not the majority of those voting at a meeting. And that's a change from 2023. So it's a majority of the entire membership. When does the 4-meeting requirement start? It started on July 1. I already kind of answered that questions. Does the annual meeting count as one of the 4 meetings to meet the state requirement? I really can't answer that. I was interpreting it to be a board meeting, but you can go ahead and have a board meeting either immediately before or immediately after the annual meeting. That's perfectly acceptable. And just recognize that you'll need to allow questions related to your current construction projects and financial operations. So if you do your organizational meeting immediately after the election, you'll have to expand the content of the organizational meeting if people want to ask a bunch of questions about what's going on with regard to financials and what have you. As a condo owner, will I now be able to get the email addresses of my fellow owners? I don't know if I put that in the slides, but the roster list, as an association, you're required to maintain a roster list. The roster list has to include the owner's name, the owner's unit, the address that you use for mailing purposes. So if the address is not the address of the unit, you have to put whatever address they have. And if the owner has consented to electronic mail for notices, the email address goes in the roster itself. So you do include the email addresses for those that you have written consent on file to use email for notice purposes. Now, owners can also consent to include their email address in the roster or in a book, directory or what have you, and those can be included as well. But if you want to keep your email private, and you have not elected for email as your official notice, then your email address will be excluded from the roster. Um, so there's a question about the pilot program, where there are villas and townhomes, but it's a condominium association. And I am implying it says, do the clubhouses need to have 100% unit owner vote? The way the statute is designed is that the hurricane mitigation hardening will be to buildings in which there are residences. So the state is not going to approve hurricane hardening for clubhouses and non-residential buildings. Oh, I have another one on that as well. Okay, so I've not been able to find out how to advise DBPR of our SIRS. That email address is in there. Go ahead and email them the SIRS, and then you will receive. They promised me, they promised a few people that if you report early before the form is created, they'll get in touch with you to say, okay, thank you so much, but we still need this other information. Okay. When our board meetings are recorded, should they be available on our website? It's not required by the law. Most of the practitioners that I work with throughout the state do not recommend archiving, recording the board meetings and keeping the recordings, whether they're video or whether they're audio. But those meetings are, if you do maintain that audio or that video, it is an official record and it is subject to inspection. So if that is your goal, I see no reason why they shouldn't be on your website, but in a password protected area so that it's not accessible by, everyone. It's only accessible by your, by your members. Can a managed association pay for board of directors training, including clam training? No reason they can't. Now, most of the things that I talked about, our classes, just like this one, are always without charge. But there are entities out there that perform board member education for charges. And of course, there are many providers that charge for CAM continuing education classes. In my opinion, those are both proper common expenses. If it's included either in your management contract or in your employment agreement, and for the board members, I think it's an appropriate expense as well. What constitutes a manager's conflict of interest with contracts? Well, if they're going to derive any benefit from it, any pecuniary benefit from it, whether it's themselves or a member of their immediate family, and it doesn't necessarily need to even be a 100% a financial benefit, it could be another type of benefit, then that is considered a conflict and that must be disclosed. So the easy one is my husband has a painting company and, I think they're great. So I say, hey, please get a bid from my husband's painting company and I'm the CAM. The contract itself or some kind of disclosure needs to be made on the contract itself, whether it's an addenda or a cover sheet or something. And I have to present you with a bid from a company that I don't have that type of relationship with. Yeah. What happens if someone on the board does not want to attend the class and there's no one to replace them? You know, what happens if no one wants to be in the board if they have to do classes? And what happens if the board members are in their 90s and does not understand technology? These are all really valid and important questions. Board members can be removed if they are not interested in obtaining the education. But if you have no one else to serve, you know, you're in between a rock and a hard place. So you are going to have to maintain at least a shell of a board, regardless of whether or not they have taken the class. And if they're removed, you're going to be forced into a receivership. So if you don't have a board, you have to have a receivership. And that is just not a good solution or result for anyone. So for those people that really are loath to take these classes, it's not that big of a deal, especially if you break it up into different sessions, so you don't have to sit there for 4 hours. For the person that's in their 90s, they may not be 100% mobile, so getting them to physically attend a class may be a little bit even more difficult. But if you're a CAM or you're a neighbor or you're a fellow board member and you know how to get on the computer and get on one of these webinars, why not bring your laptop over to their house so you can watch it together? What's wrong with that? Easy peasy. And that way you can both talk about it if you have questions or you want to discuss what's been going on. And I hope we don't have many of you in that situation. Mm. Okay, so here's a question I get a lot, and this does happen. What if the president held contracts and refused to give them to management and now has been voted out and refuses to turn them over? So there are remedies. I mean, not only can you go through DBPR for enforcement purposes, and DBPR has the ability to fine people that fail to turn over association records, but you can sue them for the records. And you can conduct discovery, because this question goes on to say that all the correspondence is on personal email. Well, if they don't want to give you their personal emails, they don't have to give you their personal emails, but they have to give you the correspondence that has been furnished by outside people or what have you, or you know, your attorney correspondence or anything that's important for your correspondence. So, I mean, hopefully you won't be in that position. You won't have to spend the time, the money, the aggravation to go through litigation. But for you directors out there, these are not, if you're the only one that's being emailed, this is not your personal record. This is a corporate record. If you're the one being emailed the contract, you go ahead and DocuSign it, even if you have authority. I'm not saying you're doing anything wrong. You go ahead and DocuSign it, then you are the only one that receives a fully executed copy of the contract. You have to have a system for delivering that contract to the association. You're not working with management, you're going to have to set up some kind of a cloud computing or an office, or you know, print it out and put it in a box, whoever you keep your records. But these are not your personal records. While you're entitled to keep personal records, that if you're the only source to which the records are being delivered, you have to give them up. They're association, they're corporate property. And that's the same thing is true with the management agents. It's corporate property. They have to give it back. Uh, What's to prevent an association putting up a terrible, confusing, incomplete, hard to navigate website and simply responding to a records request saying, well, it's on the website? Okay, that's the 21st century version of, I'll meet you at the storage shed at 11 next Tuesday. I have to tell you like a little quick personal story, because we're a little bit over, but I did have that where it was self-managed. There was a room, an unused room at the condo that was full of cobwebs and rat droppings, and like nobody ever went into this room. And over the years, people had just thrown records into boxes, you know, willy-nilly, and put them in there. And we had a very big problem with the division. Not only did I have to go in that room with one of the directors and try to find stuff, the division didn't believe me when I couldn't find some of the things that I was looking for. So they sent out two investigators. They were not happy about going in that room. It was a problem. So with the website, there are requirements that certain documents be clearly evident, like meeting notices and contracts and what have you. The division now will have the authority to go on the website. If you have this type of a complaint, the division will have the authority through its investigation to say, okay, Happy Land Condo, give me a password so that I can get into the website so that I can see what you're talking about. And if it's completely convoluted, like you're talking about, then I would venture to say that they'll issue a violation, or they'll require the directors to say, or give you instructions on how to find the documents that you are looking for. That's a good question, though. You know, I'm telling you, these record inspection things, I mean, they're so aggravating. And I know it's laborious. Maintaining records is laborious. I mean, even for my own personal records, you know, the role of, you know, my car repair records and, you know, all of your bills and all that other stuff. I mean, who knows where you put all that stuff, but you're not doing this for yourself. You're a director of a corporation. The corporation has corporate obligations. There's a question about building permits for private interior projects. No, when I talk about building permits, I'm talking about permits for work being performed by the association, you know, whether it's common element or other portions of the property for which the association bears responsibility. I know a lot of clients do require the owner to submit a copy of the building permit so that they can put it in that owner improvement or alteration and improvement file. So they have that information before the contractors show up, but that's not what the statute is really talking about. Can records be provided electronically, invoices through Avid? I'm not exactly sure how the Avid program works, like if you can give other users access, because I know that the board members get access because you have to go in and approve the invoices before they'll issue checks. But there should be a way to download the records from Avid, and then you could either upload them to your website or you could just email them over to you know, to the person that's requesting the records. There's someone that made a note that certain records are not available for inspection. Those are clearly listed in the statute. Personal identifying information about individual unit owners, any medical records, personnel records are not available for inspection. Records subject to either the lawyer client confidentiality privilege or the work product privilege are not available for inspection. So you don't need to make those available for inspection because they're not available for inspection. Question about, hey, should a request for records need to be in a certified letter? That's up to you. You have the authority to adopt rules and regulations for record inspections, and I strongly encourage that you do so. If you want to make sure that there is some kind of outside record of delivery of a certain record request, then the arbitrators have already validated or enforced rules and regulations requiring owners to submit record inspections via certified mail. I think the deadline for the website is January. So by the end of by January 1, 2025. Once a website is on, this is a good question. I like this one. Once a website is online, we can refuse to print them out, or we're still obligated and can charge per page. So great question. If the record is readily available on the website, you can say this contract is on the website. You don't have to print it out and make a photocopy for them, or print it out and that's the copy for them. You know, you have to be reasonable in this world. If it's the 90-year-old person that is not computer savvy or computer literate, well, okay, then you're going to have to make some other version of the contract available for them. But from the website, you know, you can print it out and you can give them a copy. But the statute now says having it on your website, directing people to the website constitutes compliance. I think that's fabulous. Let me scroll down. I got so many here. Does the quarterly meeting need to be separate from the regular monthly meeting? No, no. Uh, okay, so we are way over 10 minutes over, but there's a whole lot more questions here. So like last time, I'll ask Mariel and Jeffrey to send me the list of questions, and that way hopefully I can aggregate some of them, and and uh and give you supplemental answers, because it's impossible. It will be impossible. There are actually 71 that have not been answered yet. So
Thank you so much,
I
Lisa.
appreciate that you're paying attention and that you do have questions. At some point, in the fall and through the winter, if you're in Broward County, please join us or actually ACE has seminars in Broward County, they have in Palm Beach County and other places. So please join us live so that you can ask some of these questions to not only to me and the other attorneys that participate, but to some of the other professionals like the engineers, like the contractors, and get a better idea of how you're going to navigate through these new laws. Thank you for attending today. I'm Lisa Magill, and a pleasure to be with you.